Hello everyone. Here is my presentation for criminal justice and human rights. My topic is the principle of favoring the accused when in doubt and the protection of human rights under the criminal law perspective. I'm Chen Siqi from University Kebangsaan, Malaysia. Here's my contents. Part 1 Introduction. Part 2 The concept of the principle of favoring the accused when in doubt. Part 3 The definition of in doubt. Part 4 The problems when applying the principle of favoring the accused when in doubt. Part 5 The reasons for the problems faced. Part 6 Recommendations. Part 7 Conclusion. For introduction, the issues is inconsistency between theoretical research and practical application of the principle of favoring the accused when in doubt in China. This caused that the human rights of the accused cannot be protected. And the research objectives of this topic is definition of the principle of favoring the accused when in doubt and the difficulties faced by human rights protection when applying this principle in China. And I will use qualitative method as the research methodology. And the findings will include the reasons for the difficulties faced by human rights protection when applying the principle in China, and give some recommendations for China. The concept of the principle of favoring the accused when in doubt, and this principle also can be called in dubio pro in Roman. It's a criminal law principle that emphasizes that in the process of criminal proceedings, if there is a situation that is inconsistent with legal understanding or there are doubts that cannot be excluded in the process of proving a case, an explanation or fact finding should be made in favor of the defendant. The definition of in doubt includes two aspects. Aspect 1. Doubts exist in the interpretation of criminal legislation. The principle of legally prescribed punishment for specified crime requires that the provisions of the criminal law must be clear, but it is necessary to leave room for interpretation in the written record, so that the criminal law can maintain a certain degree of tension in order to better solve practical problems. At the same time, the characteristics of language make it impossible to express the criminal law absolutely clearly. And every judge will more or less have a different view of the same provision, and this leads to doubts about the application of legal provisions. Aspect 2. The facts of the case are in doubt. In the processing of restoring the facts of the entire case, if a certain part of the facts cannot be ascertained and confirmed, the judge will be unable to make a judgment based on the facts. The problems when applying the principle of favoring the accused when in doubt. The first problem, there are different views on whether or when the principle of favoring the accused when in doubt should apply. And here is some articles from Supporter. A study on the defendant favorable doctrine wrote by Qiu Xinglong in 2004. Basics in favor of the defendant in case of doubt and positioning favorable defendants wrote by Xin Xinyu in 2012. And these are the supporters' articles, which agreed to apply this principle in China. For the opponent, can be divided in two parts. First one, cannot apply when provisions are in doubt. Lin Sanjian wrote the principle, said that the principle of varying the defendant should not be used because of insufficient understanding of legal knowledge and the inability to clarify difficult issues in criminal law in 1998. 2. Can apply when only facts are in doubt. Hans Heinrich Jacek wrote, if it can be proved that there are multiple factual possibilities in a criminal case and there is more or less hierarchical relationship between these facts, if only the possibility of facts in favor of the accused can be proved, and the other factual possibilities cannot be identified, then the principle in favor of the accused in doubt should be used. And in German criminal law textbook. And the existence of these two opposing views has led judges to adopt the most conservative approach, that the principle does not apply, in order to avoid disputes in judicial decisions. The problem 2. Lack of relevant legislation. Although the relevant legislations in the criminal procedure law reflect this principle, there is not relevant expression in the criminal law. In criminal procedure law, Article 175, bracket 4, with respect to a case for which supplementary investigation has been conducted twice, if the People's Procuratorate still believes that the evidence is insufficient and the case does not meet the conditions for initiation of a prosecution, the People's Procuratorate should decide not to initiate a prosecution. And Article 200, bracket 3, if the evidence is insufficient and thus the defendant cannot be found guilty, he shall be pronounced innocent accordingly on account of the fact that the evidence is insufficient and the accusation unfounded. In China, there are still cases where the Supreme Court's answer is used as the basis for judgment. However, in different cases of the same crime, the Supreme Court's answers are contradictory, which shows that the Supreme Court's own understanding of this principle is constantly changing. And the reason for the problems faced. First one, misunderstanding the theoretical connotation of the principle of varying the accused when in doubt. The opponent's theorist's point of view that a variety of interpretation methods should be adopted in order to obtain the legal and reasonable results in interpreting the law is correct, but to deny the value of the principle of varying the accused when in doubt in the interpretation of criminal law is to distort the connotation of the principle. When the law is in doubt, the principle of varying the accused when in doubt is not generally applied. This principle is applied discriminately, and the crime law interpretation system is inspected as well. When interpreting criminal law, applying the principle of favoring the accused when in doubt not only makes it conform to legal values, but also soften the rigid system of criminal law interpretation. The application of the principle of favoring the accused when in doubt will not lead to an error in judgment, provided that it does not violate the principle of legally prescribed punishment for specified crime. 2. Ignore the requirement of human rights protection in the principle of legally prescribed punishment for specified crime. 1. Break 1. The core of the principle of legally prescribed punishment for specified crime is the protection of human rights. China's principle of legally prescribed punishment for specified crime not only requires punishment of crime, but also emphasizes human rights. However, its core content is no punishment if it cannot be convicted, which is biased towards the protection of the basic rights of individuals. 2. In China, which is a country ruled by law, when the country wants to pursue criminal responsibility of citizens, it must prove the guilty of the accused through the public prosecution. The debt between the accused and the public prosecutor is actually a tit-for-tat conversation between the individual and the state. Compared with powerful state organ, the statute and rights of the defendant is in disadvantaged situations need to be improved in order to prevent the defendants from being unfairly treated in litigation. Opponents hold that the principle of favoring the accused when in doubt is an extension of the principle of legally prescribed punishment for specified crime, but also restricts the principle of favoring the accused when in doubt, which contradicts the purpose of protecting the human rights of the defendant. Recommendations. I think China need to emphasize the use of human rights protection as a benchmark for measuring value. It's to advocate that the value of human rights protection should be considered in the judicial process, since the past one-sidedly believed that punishing crimes is to protect the human rights of most people. It did not do enough to protect the human rights of criminal defendants. Many unjust, false, and wrongful convictions warn us that when fighting crimes, we cannot sacrifice the human rights of the accused to achieve the purpose of punishing crime. Conclusion. It has always been a major problem in judicial practice to deal with cases in which the application of the law is doubtful and the facts are doubtful. The handling of such cases is of great significance to the justice of criminal justice and the protection of the human rights of the accused. Whether or not to apply the principle of favoring the accused when in doubt will directly affect the defendant's personal rights or human rights. There are many controversies in theory as to the connotation, scope, the application, and the theoretical orientation of the principle in favor of the defendant in doubt. And there are also various problems in the application of specific laws, which shows the necessity of studying the principle. By understanding the principle of favoring the accused without, this paper analyzes the problems and the reasons encountered in the application of the principle in China. Analyze the relationship between the principle and the protection of human rights, and then put forward with the protection of human rights at the core for improvement to make the principle. The application in China is more reasonable and contributes to criminal justice and human rights protection. Thank you so much.